My presentation of today changed its focus a little bit in order to avoid overlap with the presentation of the next speaker, of Dr. Christoph Harsche, as Dr. Harsche will touch more fundamentally on the subject of litigation and arbitration and law as a location factor. So I will touch on dispute resolution only very lightly. My presentation will concentrate on the IAPH Legal Committee and the legal topics dealt with by the participants in this committee. So there it is about the attention for law as well, not as a location factor, but as a very important and practical and motivating factor to be a member of IAPH. In this context, I will unveil the work plan of the Legal Committee, and next to that, I will consider IAPH's legal manual, which is called Introduction to Maritime Law for Port Officials. And I will conclude with my own experience when handling an important international contract and dealing with the issue which very often is underestimated, the jurisdiction clause. The Legal Committee of IAPH is a technical committee, and just like in any other association, technical committee, the technical committees are the backbone of the association, where very practical and assistful work is done for the members. In IAPH, 9 technical committees are active. These committees are grouped under 3 umbrellas. The Communication and Training Group, the Port Security, Port Safety and Environment Group, and the Legal Committee is part of the group together with Port Safety, Port Security and Environment. And the technical committees are aimed at sharing information between members and at formulating best practices concerning relevant issues. The technical committees are also meant for preparing standpoints which have to be taken for intervening in international arenas and forums like IMO, Michael just talked about, ILO, UNCTAD, UNCITRAL, WCO, OECD, etc. And every 2 years, on the basis of its mission, the Legal Committee formulates, just like any other committee, its work plan to be assessed by the board. And now the work plan for the period 2015-2017 is active. As you can see, the work plan of the Legal Committee is a mixture of relevant actual developments of what is going on in the international arenas and organizations, and what is useful for ports to be informed about from very practical legal perspectives. And in this context, I want to elaborate a little bit more on the work plan item concerning the legal manual, the Introduction to Maritime Law for Port Officials. Port authorities and port officials from all over the world encounter various problems in their daily work involving ships that intend to visit their port, ships that are currently in their port, and ships that have visited their port. And although these issues may vary considerably by nature, there is one aspect which all seem to have in common, and that is that there is always an international legal connotation because a ship, its owner and its crew are foreign. And in order to address this issue of internationality of maritime law, IAPH started to build a legal database with an overview of all international maritime conventions relevant for ports. And the legal database of maritime conventions relevant for ports became active after the IAPH conference in Shanghai in 2005. But the database Also, a legal database is just a database. It is very static, and gradually it appeared that, in addition to the inventory of the conventions, a wider format was found useful. Therefore, it was decided that a general introduction to various subjects of maritime law should be prepared under the auspices of the Legal Committee of Iph. And this resulted in that manual, the Introduction to Maritime Law for Port Officials, which was designed to provide the reader with an introduction to this complex and specialized areas of law. The structure of the first volume was prepared in cooperation with Professor Frank Smele of Erasmus University, who laid the groundwork with chapters on how ships are regulated, on limitation of liability, and an overview of maritime conventions relevant for ports. Chapters on more specialized subjects followed and were kindly provided by the International Tribunal on the Law of the Sea here in Hamburg, ITLOS, Professor Gert-Jan van der Ziel from the Netherlands on the United Nations Convention on Contracts for the International Carriage of Goods wholly or partly by sea, the Rotterdam Rules, and by Dr. Anthony Morrison from Australia, who wrote chapters on places of refuge for ships in distress, particularly sensitive sea areas, SOLAS, and the law of salvage. Porteous catered for a study on port regulation, which is very useful for ports considering or reconsidering their strategy for the public nautical regulation of their port. And in that chapter, which is more an appendix to the manual, you will find a good overview of all the all techniques which are used for regulating a port from a nautical point of view. So that is very helpful for ports who are rewriting their port regulations or want to know how it is done in other ports. By working in this way, a manual came into existence intended for port officials as an orientation. The perspective chosen and the topics selected reflect what is or may be relevant to them and their work. And the main aim is to provide the reader with, as the title indicates, an introduction into this rather complex and specialized area of law. An introduction to give them an overview of relevant sources of international maritime law and to provide easy access to these legal sources in combination with the regularly updated legal database which is on the website of IPH. In more recent times, it has become clear to the Legal Committee of IPH that the manual could become an avenue for introducing to port officials new and evolving areas of relevant law. In this context, the most recent shoot on this legal tree is a chapter on insurance, which is prepared by the TT Club and will be introduced later on by Marcus in this legal slot. And what we experience is that this manual serves as a point of first orientation for smaller ports, for medium-sized ports who don't have a big legal department, or for big ports who have outsourced their legal department. So this is not, of course, a thing in order to promote outsourcing legal departments, but it is really a good orientation for smaller and medium-sized ports in order to find a first orientation on these complex subjects. Now, a few practical words about the jurisdiction clause in international contracts before Dr. Christoph Harsje pays attention to this subject more in depth. If two international parties are concluding a contract, the jurisdiction clause is essential in the context of where, the forum, and under which concept of law a dispute will be resolved. The normal course is that parties seek neutrality, but how and where neutrality is sought is often very underestimated. parties are not always fully aware of the consequences of a particular choice. Be aware of boilerplate contracts where the choice is made for you. Pay attention to and take your time for a considered choice. In the first place, do you opt for a court procedure or should it be arbitration? And under what type of law, civil law or common law, should be litigated? My experience is that the party coming from the family of civil law countries, you should be very careful to opt for common law. In such a case, principles and techniques come into play you might not be experienced with if you are based in a civil law country. Next to that, there are cost differences. Under circumstances, litigating under common law is considerably more expensive as in common law systems. And the causes are disclosure proceedings, extensive pleadings, and cross-examinations. In other words, the message is stay as close to the legal methodology you are acquainted with. This is also the background of the idea of Hansa Arbitration. The so-called Hansa cities have all a strong commercial thrive, have historical ties through commerce and trade, and are located around the North Sea and the Baltic Sea. And accidentally, these countries are all in the family of countries with civil codes. Germany, Denmark, the Scandinavian countries, and the Netherlands. And the device is, seek your neutrality close at home and in the family of law you are acquainted with. So, if a Danish and a Dutch party conclude a contract, they might find their neutrality here in Hamburg, arbitration in Hamburg. And if a Danish and a German party are contracting, they may find their neutrality in Rotterdam. So the idea of Hansa Arbitration is to operate your legal footprint as close as possible near home. It means cost saving and a certain level of being able to understand the dynamics when it comes to dispute resolution. And finally, seek advice before you deviate and you opt for another type of law you are acquainted with. Thank you for your attention.